So hello, my name is Victoria. I am one of the estate planning attorneys with the Kopenberger Law Firm. One of the things with Kopenberger, for those of you who have not worked with us before, is we really take seriously education. We want to make sure that not only are our attorneys staying up on education and what's happening in the law, but that we also then translate that to our clients. One of the things that we really emphasize is making sure that things are done ahead of time. And one of the ways that we can make sure that happens is by giving you the information that may be necessary to make a decision of, do I need an estate plan? Do I need to update or modify my estate plan? And essentially check the box that says, I have done what I need to do to make sure that my assets, and my beneficiaries all have the necessary protections before I'm incapacitated or have passed away. So, first and foremost, we want to make sure that you have an estate plan. That is the cornerstone, that is the foundation of what we're going to talk about, is making sure you have an estate plan. But after you have an estate plan, the journey doesn't stop there. It's then important to make sure that as your life changes, as the law changes, that you are keeping that estate plan up to date and relevant. One of the worst things that we can see is somebody who took the amazing and great step of setting up that estate plan, but they then let it sit for 20, 30, 40 years without ever touching it, never updated it to their current life or their current legal needs, and have now become incapacitated or have passed away. What that essentially means is they can't update it anymore. And as a result of it being so out of date, unfortunately, there can be fairly catastrophic results, a lot of times involving court, which involves expense and time. So today, the biggest thing that I want you to take away is, for one, if you don't have an estate plan, making sure that you get that established. But the other piece is, if you again have that estate plan, making sure that you know, here are the certain things I need to be considering. If I don't know if they're up to date, I'm going to come in. If I know they are not up to date, I'm going to come in and make sure that that is accomplished. If you don't know us or you haven't been to see us in a while, a lot of these faces may be new. So we have been growing over the last few years and have welcomed a number of new attorneys. So not only have we expanded our estate planning side a little bit, we have also expanded our business and tax and our estate administration and estate litigation departments. With Kopenberger, we do not just do estate planning. We're also there to walk alongside the family after you have passed away. We're there to help you with your business and tax needs. And if court ends up being a necessity, we're also there to walk alongside you or the family through litigation. A lot of what we talk about today, though, is how to avoid the litigation side, how to avoid the court necessity, and to help ensure that there's a smooth transition, or at least a smoother transition, after you or a loved one has passed away. Our staff is here to walk alongside our attorneys and make sure our clients are given the best service that we are able to provide, and make sure that those needs are met in a timely manner. So if you do have questions, and it may be sometimes a simple question, you just need a quick answer, our staff are here to make sure that those can be done in a timely manner. We also have offices all over the state. And so if you have moved out of one of our main office locations, odds are we actually still have an office near you. If you have family who needs to come in and see us, again, the odds are we have one in their location. However, we can also do pretty much all of our services via Zoom and over the phone. And so if you're not in one of these areas, if you've even moved out of state, we can still be there to assist and help you or your family. Now, why does estate planning matter? So there are a myriad of different reasons that estate planning matters. First and foremost, it is to make sure that your wishes are the ones ultimately carried out. So whether you're incapacitated or have passed away, it's still your life. It's still your assets. It's still your family. And your wishes should be there in writing to be then carried out by those that you trust. So it's extremely important to make sure that those, again, are in writing, so that the person left in charge knows what your wishes are and has the appropriate legal authority to carry out those wishes. Another big thing is, I mentioned incapacity. One of the pieces that is often missed in estate planning is what happens if you're alive but not well. It's not just what happens after you have died, but there's that intermediate period where you may be again alive, but you're no longer able to care for yourself or for your finances. And making sure that you have the appropriate documents in place so that that can be done is crucial. Avoiding legal disputes. When you don't put it in writing, when it's out of date, when it's unclear, when it doesn't match what the law says, legal disputes come up. Now, most legal disputes that we see were and are avoidable, but it takes that step of coming in, meeting with your attorney, and making sure things are up to date and legally valid to then avoid those avoidable legal disputes. Now, sometimes beneficiaries, no matter how much you do, no matter what you say, beneficiaries are still going to fight. Greed and grief have a frighteningly powerful effect on people. And so sometimes it is unavoidable. And that again is where our litigation attorney can step in and help. And then another big one that is often not realized is we can minimize avoidable taxes. So obviously, we're never going to say you shouldn't pay your legally required taxes, but there are a lot of tax laws that have loopholes in them that you may not realize you could be taking advantage of. One of the things at Copenberger that we really emphasize is making sure that you do not, or your estate does not, have to pay unnecessary taxes. And so within your estate plan, we can do a lot of things to help ensure that those assets you have built are maximized and the majority can then be passed, or all of it can be passed to whomever or whatever you would have wanted. Now, for those who don't have an estate plan, one of the biggest pieces here is that an estate plan is not just one document. It is a comprehensive set of documents. For those of you who do have an estate plan, if it was not done with Copenberger, it is really important to make sure that as I go through, you're checking off and saying, yes, I have this, or, I'm not sure if I have it, or I flat no, I don't. And if you're in those latter two categories where you don't know, or you know you don't have it, it's important to come and meet with us to make sure we can get these protections in place. Each of these documents has a specific purpose, and then as a result, a specific protection power. The first one that every person over 18 needs is an advanced healthcare directive. Back in 2004, the law changed to say that no one has an automatic right to make your medical decisions, not a spouse, not a child, not a parent, as soon as you hit 18 years of age. So what does that mean? If you can't give a verbal instruction to a doctor that says, this person has the authority to act if I can't, you have to then have that permission in writing. So if you don't have the ability to verbally say it and you don't have it in writing, no one has the authority to make those decisions for you. This could be you're in the middle of a surgery and a decision needs to be made on what path do we take? Do we go with path A or path B? This can be palliative care. This could be end of life, organ donation, life support, those sort of things. Those decisions, that authority needs to be in writing. The other piece of having it in writing is not only does it ensure you have protection and you have a person in place who you would want to make these decisions that are very intimate decisions, it can also take a lot of the burden and stress off of the person that you have named. When you're in the position, which I unfortunately have had to be in, of making decisions like, do I put someone on life support or is it time to say goodbye? One of the best, as weird as it may sound, gifts that you can give someone is having in writing what that wish would be. So my grandma was the person I had to make this decision for. And she had in writing on her advanced healthcare directive that if she got to the point where she would not recover without being then placed on life support, to basically be just sustained, but never to actually live again, she said, I don't want that. And so when the question came of, okay, do we put her on machines to at least keep her body physically here? The answer was very easy. She had already made that decision for us. And so I didn't have to feel guilty. I didn't have to hem and haw. I knew what she wanted. And so it took a lot of guilt. It took a lot of that burden and weight off. And I knew I was honoring what she wanted, even though she couldn't communicate it anymore. So putting this in place again, not only ensures you are protected, but it gives that a lot of peace of mind to the person making those choices. Now, if you already have this healthcare directive, it has to have been done since 2004. If you have one that has been done prior to 2004, it will not be accepted and honored at this point. The reason, again, is the law changed. And so your healthcare directive has to have specific language that complies with the current HIPAA policies and laws. If you don't have one since 2004, Now is the time to come in and see us so that we can get that updated or set up for the first time. Now, the other document that goes hand in hand with this is your durable power of attorney. This is the document that gives somebody the authority to act on your behalf if you are no longer in a position to want or be able to manage your own finances. Now, finances are, and for some people, equally as intimate to the medical decisions because our finances can often be what we need to take care of us as far as the care we might need in home. Do we need assisted living? How do I make sure the lights are kept on if I can't now pay my own bills? So, you again have to have given somebody the authority in writing to manage that money for you. Again, we recommend very strongly this be somebody that you trust. So if you have questions on who that person can be, we can also help walk you through that. Now, this document also needs to be kept up to date, but it has a different rule. Since COVID, there have been significant restrictions put on these powers of attorney. If you have a durable power of attorney that is older than 5 years old, most financial institutions will not accept them anymore. And the reason is they are trying to crack down on financial fraud and elder abuse. The idea is that if you have created a power of attorney 20 years ago, you may not, if you became incapacitated today, still want that person named. It still may not be an appropriate person to be named. So they have been rejecting them if they are older than 5 years old. Now, this was a policy shift that banks have implemented. This was not a law. What that unfortunately means is banks get to set the rules on this. We just then have to go along with it. What I have told all of my clients is updating this document may seem like a pain, but it is significantly cheaper and more pain-free than if you risk leaving your document out of date and wind up needing the court to get involved. And I'm going to talk about the court involvement here in just 1 minute. So if you have a power of attorney that is older than 5 years old, now is the time to come in. If you don't know if it is, bring your documents in and we are happy to take a look and either say you're still completely protected and fine, or yep, now is the time we need to get this document updated. Now, why did I mention court? So the issue in part of not having the healthcare directive that's valid or a valid financial power of attorney is if you become incapacitated and you do not have those documents, the court then has to decide who gets the medical authority over you and who has financial authority over your assets. Anytime the court is involved, it essentially means that you did not put wishes in place or you did not have the appropriate up-to-date documents in place. And a lot of times then what we see is it's all in the court's hands, which may or may not mean that your wishes would be the ones carried out. The court ultimately would then get to decide who's making those medical decisions, who's making the financial decisions, and they can even have influence in what those decisions are. They can dictate that somebody has an extreme authority, a general authority, or no, you only have a limited authority. So it can still leave you in an extremely vulnerable position. So this is where just having those two documents valid and up to date can make a world of difference for you, for your family, and ultimately for the care that you would receive. Now, the next step is your children. So if you have minor children, or if you're here watching this and you have minor grandchildren, one of the things to make sure is that parents have put in place who would be a guardian, even temporarily, if the guardians that you ultimately want are not in the immediate vicinity. So, guardianship in general, most of the time, what we're talking about is who would ultimately have guardianship of your child if you were to pass away before they were 18. But for some of our clients, they're naming guardians who are out of state or even out of the country. So, what happens if, God forbid, you pass away unexpectedly and those guardians need time to get here? Even if they got on the quickest flight out here, that could still be hours or even days until they were here to take care of your children. So one of the things that can be put in place is what is called a temporary guardian. Basically, this is the person who we want to take care of our kids for a moment. So sometimes this will be the child's grandparents. The grandparents may be older, they may not be in the position or the right person to have the kids permanently, but at least for a day or two or three or a week, they could have the kids to make sure that they don't become wards of the state. So this is an extremely important role where, again, if you're considering guardians that are not in the area, or would have a hard time potentially getting to your children within an hour, basically, of your passing, consider naming temporary guardians in a separate document. If this is something of concern to you, if you have more questions on this, absolutely come and talk to us. Now, a lot of questions come after we've talked about the healthcare directive and the power of attorney. It now comes to, okay, do I need a will or do I need a trust? Most people know the term will. Less people understand what a trust is and why it is so important in California. So a will is only going to be protective enough for your estate if you do not own any real property, so no homes, no investment properties, no rental properties, and or you have less than $184,000. If you own real estate or your dollar figure is higher than that 184,000, a will not protect your estate from court. So this is a different court process. This is now what is called probate. This means you have passed away and your estate is now subject to the court's decisions. The court now gets to step in and decide who's going to ultimately be in charge of settling your estate, who ultimately is going to be in charge of collecting or paying any debts, and ultimately they get to decide where does your stuff go and how. Anytime, again, the court is involved, it is more expensive, it is more time consuming, and a lot of times it is more emotional because anytime you are in court after someone has died, again, I'm unfortunately speaking from experience here, it feels like a wound that keeps being picked at. So after my grandma died, I have one of, unfortunately, those families that is not picture perfect and people wanted to fight. We had one of my grandma's beneficiaries want to go into court. And essentially, every time a court hearing came up, a court issue came up, it really did feel like a scab being ripped off a wound. Because here we were again having to go into court and fight over things that shouldn't have been being fought over. And it was exhausting. The other thing, again, though, is it is time consuming. My grandma passed late 2019. I was in court with some of her beneficiaries as her trustee and executor until just last year. It is extremely time consuming. And a lot of reason that it took that long was because the court sets the dates. They set the time frame. And so even if you have a court hearing in June, they may not set the next one that you have until January. I watched one that wasn't set until a year later. And so it's extremely time consuming. The average probate at this point takes anywhere from 2 to 5 years because it is such an impacted court system and it is so slow. The other big issue, again, is cost. So probate takes 5 to 7% of the gross estate that they are overseeing. What that means is if your home could be sold for $1 million, it has an appraised value of $1 million. They do not care what equity you had, what mortgage was left over. They will put the percentage on the entire value of that home. And so if you do have debts, if you have mortgages, you might have car payments, you may have other loans outstanding, that's not going to help. It's going to hurt because it starts then just depleting the estate more and more and more, leaving less and less and less for the people that you would have wanted it to go to. So how do we avoid that? Well, the great news is you can do that by setting up a trust. So a trust essentially answers all of the questions that the court said your will did not. It says who's going to be in charge if you can no longer do the job. If you can no longer manage your own assets and settle the estate because you've passed away, you get to decide who that person or entity would be. You get to decide who ultimately is going to inherit from you and when and how. Because just because you have a beneficiary doesn't mean the moment you pass away that that person would automatically be in a responsible enough position to manage the money immediately. Maybe they're a minor, maybe they overspend and you're concerned about them just blowing through the inheritance. Your trust allows you to set all of those terms so that you not only can then leave the money to the people or entities you want, but you can leave it with protections to make sure that the money is used in the best possible way. Now, one of, as I mentioned, the biggest benefits is avoiding court. But the other piece that I mentioned all the way at the beginning is tax planning. So unfortunately, taxes affect us whether we want to admit it or acknowledge it or not. That could be your property taxes, capital gains taxes, even income or gift taxes. Taxes are everywhere. And within your estate plan, you can, as I mentioned at the beginning, minimize or in a lot of cases, completely eliminate those unnecessary taxes. But the one caveat to having a trust is that it only protects what it owns. So when you set up a trust, if you've done it with Kopenberger, you would have received this instruction. And if it's with a different attorney, I hope you received this instruction. You should have been told, though, which assets after you set up your trust needed to be transferred into the name of the trust. So generally speaking, that includes your real property, so your home, your rentals, your investment properties, your checking and savings accounts, and your non-retirement investment accounts, so your regular brokerage accounts. After a trust is established, those should actually have the name of the trust on them. That way, when you pass away, the court has no right to those assets. It goes through what your trust says and ultimately then goes to who you would want. If you have not properly titled those assets, unfortunately, they can still be subject to probate. So again, when you're going through your list, take a look at, are my bank accounts in the trust? Have I refinanced my home since I set up the trust? If you've refinanced, most likely they pulled the house out of the trust and it is currently unprotected. Do I have proper beneficiaries on my other accounts? One of the other pieces is, for beneficiary designated accounts, the trust does not control. So your IRAs, your 401ks, your life insurance policies, those assets will go to whichever beneficiary is named on those accounts. For some people we talk to, they have their spouse named as a primary, but they have no contingent beneficiaries. They're assuming the trust would then take control. That is not the case. You have to make sure that there is a contingent beneficiary named on those accounts, which in some cases can be the trust, but that is case by case and should be discussed with your attorney. Now, we understand things happen. Sometimes you forget, sometimes an asset just it's fallen by the wayside and you don't have it in the trust or you do not have beneficiaries named. So what we have done for the Kopenberger trusts is we have created what is called a pour-over will. So when you have a trust with us, you will also have a will. The purpose of this will is a little bit different than the standalone will. This one accompanies your trust and basically says to the court, hey, I know that after the person passed away, it wasn't in the trust name, it didn't have the right beneficiaries or any beneficiaries. So ordinarily, you would have access and control over this asset, court. However, I have a will, and this will says you don't get to have control. You don't get to determine what happens to it. It says, give it back to my trust and basically honor my wishes. And so it's a safety net document that goes alongside your trust. It is also the document where we would name those guardians for any minor children that you have. So if you have minor children, your pour-over will is playing two roles at that point. Again, if this is a document that you're not sure you have, or it's something you need to just have reviewed, this is the time to have us do it. Now, besides the money, the other piece that we talk about is your stuff. So unfortunately, stuff can actually cause some of the biggest fights that we see. Your stuff are the things that a lot of times has emotional value after you have passed away. We hear all the time from people that my kids don't want anything. They've said, just get rid of it, donate it. We don't need it. The problem with that is that may be extremely true while they're talking to you, but what we see in almost all cases is as soon as the loved one has passed away, that stuff has a very different value and meaning because that's all they have now. They aren't talking to you. They don't get to see you. They don't get to hear your voice. And so those things become insurmountable. They become invaluable in their eyes. And unfortunately, if an item becomes invaluable in multiple beneficiaries' eyes, it can cause significant fighting over things that from a monetary standpoint may have no value, but from an emotional standpoint now have an undescribable amount of value. So one of the things that you can do if you have a Kopenberger trust is you can use what is called a letter of instruction. What this letter is it's a handwritten letter that you create. You can do as many or as few of these as you want, but it allows you to designate items to specific people. Now, your trust has to have the power for you to do this. So if you do not have a Kopenberger trust, you may or may not be able to utilize this. But with the Kopenberger Trust, you can again put in writing that I want this. By my mom got a handwritten Bible, or not handwritten Bible, a Bible that had handwriting in it from her great grandma. When my grandma passed away, she designated that my mom would get that. So those are some of the things that had emotional value and could then be designated so that no one else can fight and say, well, I should get that, not you. Nope, I have it in writing that I am the person who gets to receive this item. That can take so much of the fighting, so much of the confusion, so much of the emotion out of the issue. So if you have any questions, if you need help on how to do this, we do have a how-to, and we are more than happy to get that over to you or talk through some of those ideas. Now, one of the other things nowadays that has become very prevalent is social media, cryptocurrency, your digital assets. Now, with cryptocurrency, I'm going to touch on that just for a brief moment. That is actually still treated as personal property. It is not treated like your bank accounts or your residence or your secondary properties. It is like your stuff. Now, with cryptocurrency, one of the worst parts about it is that if you do not have someone after you're gone who has your code, your key, your chain, the access to that asset, there's no recovery for it. And so it is extremely important that you have at least put in a secure location that code, that key, that chain that someone knows to go and find. Because if you pass away and no one can find it, no one knows it, you basically have lost that asset. It is gone. So if you have any questions on that, again, please come and talk to us. Now, with your digital accounts, things of that nature, one of the hardest things after someone passes, because nowadays so many of us have things on our phones, is recovering photos, is recovering contacts, those things that are stored on our phones. One of the things that Apple now has is you can put in what is called a legacy contact. Basically, it is a person that you are authorizing within your phone for Apple that if you pass away, you've said this person can access my phone so that they then have access. They can pull your photos, they can let your contacts know that you've passed away. They have those things so that they're not all lost. One of the things that has been really devastating for some people is they weren't named as a legacy contact, and so they cannot unlock that phone. And again, most of us then store things digitally. So all the photos, all the people that you would want to let know that your loved one has passed away, invite them to the funeral. None of that can be accessed. So again, if you have any questions on how to set that up, what to do, any of that, please come and talk to us. One of the questions that is in the chat right now is what was the year for the healthcare directive? So it needs to be done if it is older than 2004. So if you have one prior to 2004, that is when it now needs to be updated. Now, beyond the basics of estate planning, so that really covered the essential documents that you need to have in place. Again, if you're over 18, a lot of those now need to be considered. But we also have some special provisions that may or may not apply to you and may apply to all of you. The first one is called a psychiatric healthcare directive. This is a new document, essentially. What we have unfortunately found recently is that for people who are in psychiatric healthcare, so not in the normal hospital, they are now in a more advanced level of care that is specialized for psychiatric healthcare. If they do not have this specific focused document, the healthcare directive is not being accepted. We unfortunately had a situation where the child had been put into a psychiatric healthcare facility. They had a healthcare directive for her, but they did not have a psychiatric healthcare directive for her. And the facility basically told her parents, we won't talk to you and you can't talk to her. And it was devastating, traumatizing. It's a parent's worst nightmare. Thankfully, she was able to come out of the psychiatric break essentially fairly quickly. But I say fairly quickly. It was a week's worth of time. And in that time, the parents again had no access to her. So the psychiatric healthcare is something that now they have and would be able to use in the future if it becomes necessary to be able to access their daughter, to be able to talk to her physicians, to be able to have her talk to them. And so this is something where if you are in a position where you or a loved one has a history of some sort of psychiatric mental disorder that may lead to you not having the capacity to make your decisions, this is a document to come in and talk to us about. The other thing is a medical directive for minors. So one of the things is what happens if you are traveling and your child is left with somebody for a temporary period of time, but that does not have the legal authority over your child. They're not a legal guardian. They're just basically an extended period of time babysitter or nanny. This minor medical directive basically allows you to appoint who would have the authority to talk to your child's doctors and to make those decisions if you were unavailable. So maybe this is while you're on the flight back home trying to get to your child, you're unreachable. This can then allow that person to have the authority to be in the room, to make your child's decisions, to make sure that they are still being advocated for. So if you are planning to travel and you are not going to be traveling with your child, and they are going to be left with someone who does not have legal authority, so basically either a guardian or a parent, this is something very much to consider putting in place. Does memory care require the psychiatric healthcare directive? Not yet. That is not a situation that we have come into yet. However, I say yet because unfortunately, similar to banks, policy and things can be shifted by the facility at any point. So that is not a concern as of now. If it becomes a concern, if that is something that we end up running into, we will absolutely make sure that our clients are aware of that. Another category of people that we absolutely want to make sure is protected are our beneficiaries with special needs. A lot of times parents or people leaving money to a special needs beneficiary are concerned that if they leave an inheritance, that beneficiary will lose all government assistance. The great news is you can set up a special needs trust or supplemental needs trust to ensure that you can still leave that inheritance to those beneficiaries and they can still keep their government assistance. The other thing with having it in an actual trust is you are essentially ensuring that the money will actually be used for their care and to supplement their care. One of the issues we have seen is where a parent has left money to one of the other kids with the intention that that child takes care of their special needs sibling is unfortunately in most cases it doesn't happen. When you leave money to one of your kids with that intent, legally you are handing that money over to them and basically hoping that they carry your wishes out. The problem is when somebody has the money, it's amazing how fast mentally we can spend that money. All of a sudden, that $1 million, we can buy a home, we could upgrade our home, we could do all of those projects we wanted to, we could travel the world. We become very we-centric. And unfortunately, again, what we have seen is where the money is left in that manner, those hopes and wishes are often not actually carried out. By setting it up in a specific trust to ensure that that person has the resources necessary, you are, again, ensuring that that actually happens. It is not left up to chance. It is not left up to somebody basically hoping that their loved one carries out their wishes. Now, for your other beneficiaries, your children. So if you are leaving money to children, one of the things is, do you want to leave it outright to them? Or do you want to leave it in what is called a protective lifetime trust? If you leave the money outright to them, generally what happens is they just put it into a normal bank account. They put it in their name, they put it in their existing accounts, and the money becomes, the inheritance money becomes just part of their now estate. If they are married and live in California and put it into an existing account with that spouse in it, that inheritance now becomes community property and it becomes subject to any debts, any obligations, legal or otherwise, that they have on a financial basis. If, however, you leave it into this protective lifetime trust, the inheritance, they can use it, they can spend it, they can buy and sell, but it stays separate from their assets and as a result is protected from all of these outside predators. What that means is if they get divorced, it cannot be taken away in a divorce proceeding. If they're in a car accident and it's completely their fault and insurance can't cover the entire amount, the inheritance will not be taken away. If they have a spouse that outlives them, that spouse remarries, it ensures that the money would actually transfer to your grandchildren or your surviving children, rather than now going to a different family that you never knew. So basically, these trusts ensure that the money can't be taken from your children and ultimately ensures that it stays in your family. So this is something, if you are concerned about that, if you don't have this provision in there and you want it, now is the time to come and talk to us. I'm checking really quickly in the Q&A section. So one of the questions that we have right now is, if there is a property in a trust and you were to pass away, is it legal to leave the properties in the trust in order to continue having a lower property tax basis? The answer is no. You cannot just leave the money or the asset in there to continue having the decedent's advantages. It does have to be transferred out to the beneficiaries in a timely manner. And if that is not done and the county assessor finds out, basically what happens is, not only does the property get reassessed, you get hit with back taxes, and they will put a penalty and a fee on those back taxes. So it becomes an astronomical problem and a much more generally costly problem than having just done it correctly in the first place. Okay. Now, another thing is, if you are married, what happens if you pass away? What happens if you pass away and your spouse then remarries? Are you okay with that spouse having complete access to the estate, basically being able to change and do whatever they want with your trust and the assets? Or are you concerned about locking in place your side of the estate? If you are concerned about the remarriage component, you can set up what is called an A-B trust. Basically, what that means is, after one of you passes away, you actually have two trusts. You have a survivor's trust that is in the survivor's full control, but you also now have a decedent's trust. The decedent's trust is one that the survivor can still use the money out of, but they can't change. So if they remarry, if they change their mind on beneficiaries, they can only change their half. They cannot change yours. So again, if that is a concern, this is one of the protections that is available. Now at Kopenberger, beyond what we just talked about, we have a lot of different special planning options. We can go above and beyond the basics of a revocable trust, and we can build in different protections for your different categories of need. So if you do have a more complex situation, if you're more concerned about other areas, please come and talk to us. The other thing is, for a lot of these topics, we now have webinars and recordings online for. And so often you can find some of this basic information in these education events on our Kopenberger YouTube page, or channel. So if you do have any questions on that, I also recommend trying to take a look at some of those prior videos. All right, another question I just had. We had our documents updated in 2023. Do they already need to be updated due to 2024 laws? My first reaction would be likely no, but the second one would be, if you have any concern, come in and see us and we can take a look and reassure you if either yes, we do need to update it, or no, you're still completely protected. But generally, between last year and this year, you should be okay. Is there a fee for a consultation? So there's two answers here. If you are an Access member, you are somebody who has 2 hours of attorney time for free. So if you're an Access member and have not used those 2 hours of time, you can use that. The other thing is, if you are obviously on this webinar or watching it later, and you have not already met with us in the calendar year, it is also free. So if this is your first appointment for the year and you are watching this right now, you would have a free consultation. Now, the next piece is, again, life changes. So when you first established your estate plan, were you single and now you're married? Do we now need to consider that AB trust for remarriage protection? Or on the reverse side, were you married when you first set it up and unfortunately have gone through a divorce and now need to make sure that things are separated? The divorce component is a huge flag to say, I need to come in and have my estate plan updated. Because just because you went through a divorce and your finances are separated does not mean that the person can remain in your documents. If they are still named as your healthcare power of attorney, they actually still have medical authority over you. If they're still named as a beneficiary in your trust, when you die, they could still get your estate back. So unfortunately, if you leave your documents alone after a divorce, you can still be in a catastrophic situation after you're incapacitated or have passed away. So if you've, again, either gotten married since initially setting up your documents, or you're now in the divorce process or have been divorced, it is time to come and have those reviewed and make sure that you are properly protected and have the right people in place. Now, your people. I keep mentioning, do you have the right people in place? So that is throughout all of your documents going to be a large conversation. Your trustees, who is in charge of actually settling things when you pass away? Did you have minor children when you first set up your documents, but now they're all adults and they would be the right people to actually take care of administering things when you're gone? Did you have friends who have passed away? They were initially named in your documents, but they're no longer with us. Did you have friends that have moved out of the area and you're no longer in contact with them? Do you have somebody as your medical power of attorney who doesn't really know you anymore, who may not have the same values that you would possess as far as making medical decisions? Are they in the area? Would they even be available to make those medical decisions? All of these roles are often very intimate roles because, again, they're dealing with your assets or you when you're incapacitated or after you are gone. And so making sure that these are the right people to make those decisions is vitally important. And ultimately, are your beneficiaries still the right people? Again, did you have minor children who are now adults and we need to reassess the protections? Did you have charities involved and now your charitable giving intentions have shifted, changed, updated, been modified? Do you have organizations that you need to remove or include? Religion, if you were at a church and now you've moved churches, do you want to update that? Your beneficiaries, again, are who ultimately get your stuff. And so we want to make sure that not only are they the right people or entities named, but also, again, do they have the right protections for where they are at now? So when you're looking at your estate plan, we very much recommend you look at what has changed in my life since I set this up. Go through it and note, okay, now that person has passed away, or that's somebody I'm not really in touch with anymore. Oh, I'm planning to move. Okay, is this document still going to be valid in the state I'm moving to? Or maybe you're moving into California. Is this still going to be valid in California? These are all things and all questions that we can help you answer. I want to reassure you that if you are moving out of California, your Kopenberger prepared documents are still valid in all of the states. Now, there may be some small adjustments, some things that need to be shifted, but we can again help you either do it specifically with us or help find someone for you who we trust in the state that you are moving to. Legal changes. This has been a huge topic since 2020. That is for a myriad of different reasons, all of which we are going to go into right now. The first one is Proposition 19. This was a 2021 shift. This changed that when kids inherit your properties, the only one that is even entitled to keep your property taxes is your primary residence. But the other piece now is it has to be occupied by the child as their primary residence. If they choose to own and rent the property, it will not keep your property taxes. And so, unfortunately, this has greatly restricted how much people can afford and if they can even continue to keep that family home. One question, do we have real estate attorneys on our team? We do not have real estate attorneys, but we do have attorneys who have dealt with property and land. So depending on the question, that can influence whether we're able to help you or if we need to get you one of our referrals. Now, again, with Proposition 19, one of them, the big concerns is if I pass my property to my children, I want them to be able to keep my property taxes, what I'm paying, and not have it reassessed. Is there any way to do this? There's two different options. The first is for your existing primary residence, you can put in what is called right of first refusal language. Basically, what this means is if you have more than one child, you can give one of them the option to buy out any of their siblings so that the distributions are all still equal, but they then have the right to own and live in the property and keep the property taxes what you pay, not the new rate. The problem is if you don't have this language and you just transfer or leave it to your kids and they start buying each other out, at least part of the property then will be reassessed. This right of first refusal language can allow the entire property to keep what you're paying, not the new assessed rate. The other thing is if you're planning to purchase a new primary residence or any property, consider setting up an LLC beforehand. If the LLC is funded with cash and the LLC cash is used to buy a new property and you pass away and the LLC transfers, your property is not then changing ownership. It is remaining in the LLC. And so that can help you then keep that low assessed or the current assessed value rather than again it being reassessed. So if again you're planning to buy a property, I very strongly encourage you to make an appointment with our business and tax attorneys to make sure that you can consider, is this right for you? One of the other changes that has been going on since 2022 is Medi-Cal changes. There was a huge shift in Medi-Cal this year. So prior to this year, if you needed Medi-Cal, they were going to look at your assets. They would say, first, do you physically need it? But second, do you financially qualify based on your assets? They no longer look at your assets, but they actually look at your income. So what does that mean? Well, for a lot of people, it means they actually may now qualify for Medi-Cal where they never could have before. But the Medi-Cal application, that whole process is extremely complex. They're basically looking to not qualify you if possible. And so a lot of times the applications, they're not straightforward. There's a lot to them, and it can be very overwhelming, especially for people who don't have somebody that can advocate and do it for them. So that is where we often step in. We can actually help you fill out the application and qualify then for Medi-Cal, because not only do we prepare those, we also work with a Medi-Cal qualification specialist who often helps answer those questions that come up. So if this is a concern, if you are not sure if you need or would now qualify for Medi-Cal, I very strongly recommend setting up an appointment, because again, this is a never before seen shift. And so significantly more people, as I mentioned, can qualify today that couldn't prior to January of this year. As I mentioned, it is complex. I very much recommend, whether you work with us or somebody else who specializes in Medi-Cal, that you really do work with a professional. Because what we see time and time again is people who just take a crack at setting it up or filling it out themselves often end up getting rejected because of something that seems very small and simple, but actually ended up having a profound effect on whether or not they could qualify. Another change that happened and started happening in 2020 is the Secure Act. So this is applicable to those of you who have retirement accounts. What shifted is that when a beneficiary other than your spouse inherits an IRA or 401k, rather than now having their lifetime to take the monies out, they now only have 10 years from your date of death. What that means is, starting in 2025, that they would have to not only take required minimum distributions, which that's the change in 2025. There were no required minimum distributions or penalties on it up until this upcoming year, but they also have to withdraw the entire rest of the amount within 10 years of your date of death, or there is a significant penalty. Now, why does this affect your estate plan? So for those of you who have or are planning to set up those protective lifetime trusts, one of the things that we talk about is, do you want your IRAs and 401k monies to also go into those protective lifetime trusts for your kids? If you say yes, then we have to talk about updating your beneficiaries on those accounts to the trust. But if you have out-of-date retirement language in your trust and the beneficiary on the account is your trust, when you pass away, that can then cause a one-time distribution, which means a one-time tax on the entire amount, which can be significant, at least significantly different than if they had had the 10 years to withdraw it. So we have updated language that complies with the new laws, but you have to have that updated and put in your trust. So if you have any questions, if you have not seen us in the last 3, 4, 5 years, you do not then likely have the language, and it is time to make sure that that is updated and that you have the appropriate beneficiaries on those accounts and that your trust has the appropriate language to protect from those unnecessary taxes. All right, skipping a little bit. So this was a lot of information. Essentially, what we recommend is that you come and see us every 3 to 5 years, because one of the things that we want to make sure is that your legacy, whatever that legacy looks like, whether it's the assets that you're leaving, whether it's your values, it's those family heirlooms and memories, whatever you want your legacy to look like, we want to make sure that your estate plan will help carry that out. Legacies, assets, memories, they can start being tarnished when things are not done correctly. Because when the court is involved, when family can fight over things that should have been protected, it can start chipping away at that legacy. It starts leaving again a tarnished memory a lot of times, unfortunately. And so by having an updated estate plan, by having things in place before things go wrong, you can help preserve and continue then that legacy long after you are gone. Now, I keep mentioning it. One of the worst things is having outdated documents. We have a lot of people who had wonderful intentions when they first set up their estate plan, who thankfully have come in to see us, but they were very much gambling with the length of time it had been between the establishment of the documents and the update and review. So again, if you have not seen us in the last 3 to 5 years, I very much recommend that now is the time to come in. As I mentioned, for the consultation, if you are an Access member or have not been to see us already, by attending today, you get that free consultation. For our Access members, you can use this time as the free consultation and still then have your 2 hours of attorney time if those have not been used yet. If you have questions, I keep kind of mentioning this Access membership. If you have questions on what that program is or what it entails, if you're already an Access member and want a recap of your benefits, reach out to us and we can make sure to go over that with you. So we have a little checklist. When are changes needed? So take a look. You can take a picture of this. This is being recorded, so it will be sent out. But take a look at your documents and think, how long has it been since I've seen them, and have things changed in my life? Do I need to come in at this point to make sure that I am properly protected and things won't end up in a disaster after I am gone? So we're here to walk alongside you. We are here to help you through those difficult conversations. We're here to walk through difficult decisions. Not everybody has easy answers. It's not always cut and dry of who's going to do what, how are things going to be distributed, what's going to happen with your care. We are here to help you brainstorm. We are here to help make sure that you have the proper protections and the right advocates in place to ensure that your wishes really are carried out. Now, if you're wondering why should you work with us, you can Google estate planning attorneys and find hundreds, if not thousands, within your area. So why Kopenberger? We have been around since 1979. And as I mentioned at the very beginning, one of the things we take extremely seriously is education. What I hear from so many of my clients who become Kopenberger clients after working with other attorneys is they never heard from their attorney. They basically set the documents up and that was it. They a lot of times don't even know if the attorney is still practicing or has died at the time that they're now coming in because they never heard from them. So when I talk about education, again, it's not only making sure that our attorneys stay up to date on all of the changes in the laws, but it's also making sure that you have contact with us. That is one of the biggest values that we can provide to our clients, is making sure that what changes, what you need to know, we are presenting and we are keeping in contact with you. So if that is something that you are looking for, come work with Kopenberger, come talk to us and see and make sure we are really the right fit for you. So we're here to help. There is in the chat a link if you wouldn't mind answering a few short questions. With the education, we always want to make sure that we really are making these tailored to our clients. And so if you can answer those questions, that would be fantastic. It lets me know how I did. It lets us and our team know that we're really providing the information that you find most helpful. I will leave this up for a bit and I will stick around to answer any other questions that come in. If you do have those, please feel free to put them in or make that consultation. Thank you so much for spending today with me. I look forward to meeting with you soon.